federal government in their copyright policy office from about the year 2000 through to 2006. For those of you who've been studying the history of Australian copyright law, you know that was a really interesting period to be there, because it was when the US Free Trade Agreement went through. It was when most of the implementation of the digital agenda amendments went through. So basically, a lot of the very relevant issues today were being dealt with over that period. They've continued to be dealt with, so I might be a little bit out of touch on some of the updates, which is why we have Nick and Trish. So what I'll be focusing on today, just to start off with for 5 minutes or so, is a bit of background on fair use and what it is compared to fair dealing and all that kind of thing, to make sure we're all up to date. I'm going to just assume that you guys are all fairly across what fair dealing is and how it works in the copyright system, but I'll add a little bit of nuance about what the debate around fair use versus fair dealing is, and hopefully we'll have some more speakers afterwards. So, the first, and feel free to interrupt me or put your hand or whatever, whenever you want. I don't even have slides this time, so we can be very free-flowing. So, the first thing I was going to bring up is like fair use versus fair dealing. What's the difference? I'm sure you all know the absolute basics, which is that fair dealing is a set of exceptions which apply to for certain purposes and certain purposes, you know, reporting the news, research and study, etc., which let you use copyright material without the copyright owner's permission, as long as it is fair. Fair use is almost identical, except that it doesn't limit itself to these specific purposes. So fair use has the same criteria that you consider: the nature of the work, the nature of the use, etc., the amount used. They're all used. They're considered in fair use just the same as fair dealing in determining whether or not a use is fair. But for the purposes of fair use, there's no limit to purpose. Basically, you could be doing anything. You could be, hey, Nick. There he is. Anyway, so basically, fair use and fair dealing are actually extremely similar to each other. But where fair dealing is limited to very specific purposes, which tend to be, you know, professional uses that happen in the public eye. Fair use is open-ended and can be applied to absolutely any use as long as it's determined to be fair. Now, where this becomes relevant is things such as private uses. So in Australia, we don't have a fair dealing for private use. We also, do we have a specific? No, we don't have a specific exception for private use either.
Yeah, we've got the time shifting and format shifting.
Yeah. We've got very specific exceptions for some private use. But we don't have anything that kind of says, if you're using the copyright material, you know, in your own home, it's okay. So anyway, so for example, there's arguments that parents painting a mural on their kids' wall of Disney characters are infringing copyright. I don't think it's even a strong argument. I think basically it's a strong argument against it. And whilst in the US that can be covered by fair use because it's open-ended. Probably more pertinent and more relevant to you know, the actual public debate about copyright is things such as posting something up onto eBay. So you want to sell your books on eBay, and your books have pictures on their cover. You put up pictures of your books on eBay, and you are reproducing those artworks, and lo and behold, you are infringing copyright unless you've got permission to do so. Fair use, once again, has the flexibility. I'm not saying there's been a court case about this, but it has the flexibility for you to say that's probably covered by fair use, or if you wanted to go to court, you could actually say that is covered by fair use, because fair use is just flexible and open that way. Under fair dealing, it'd be very hard for you to argue that there's anything you're doing, maybe criticism and review, but I think that would be pretty long bow. So the main benefit that fair use provides over fair dealing is flexibility, openness, ability to absorb new uses that haven't been thought of previously, that's the big one, as well as ability to cover small uses that nobody really cares about. In a way that means you can just ignore them rather than technically say, well, technically it's an it's an infringement, but it's probably okay from a risk management point of view.
So fair use could allow, parents. Why would you think even? I mean, I understand that it's harvested and everything that's going to have legitimized what's happening, but every time you go and sue some parents.
And that is one of the major points in this debate. Exactly, you have already caught up. One of the major issues about whether or not fair use should be adopted in Australia is exactly that point. And both sides kind of argue this back and forth. On the one hand, you have the argument that if it's not broken, don't fix it. Nobody ever gets sued for this stuff. So why would you bother changing the law to allow parents to paint murals when they're not going to get sued for it? And that's a pretty strong argument. You can put it in a less laissez-faire, less dismissive way by saying that there are barriers to enforcement such as costs and benefits and things like that that work against copyright owners enforcing the full extent of their rights in these very minor circumstances, and therefore they do not have to be dealt with. And I would certainly say that say 30 years ago, that was a very strong argument. I mean, 30 years ago, copyright really only applied to commercial and business practices. I mean, anything that happened in public, but that really meant commercial and business practices. This was the day, you had photocopiers in schools, but that was about the only way that you could infringe copyright, except a mixtape in the playground. And again, nobody was going to ever sue on that. The other side, and I suspect you're going to argue the other side, so I'll let you come in a second, but the other side of the argument to this, the one side is, don't even worry about them, it's not worth trying to change legislation to fix it. The other side of the point of that argument is that, particularly as the internet has grown, more and more uses that people undertake commonly fall either into that category of clear uses that nobody's going to sue you over and therefore why bother, or else fall next to it into this grey area of it's probably not likely that you're going to be sued, but it's not really clear because, in fact, you're doing it in public, you're doing it on the internet, and this includes all kinds of, ignoring the, more touchy piracy stuff around, downloading TV shows and music, singing karaoke on YouTube. That's a perfect example of something that, once again, people are probably going to say you're not going to be sued over, but blah, blah, blah. And more uses are falling within that. It's less and less clear. And arguably, a lot of people say, some people say that this is putting copyright into, disrepute. Basically, the more normal activities of ordinary consumers that are illegal under copyright, even if they're not going to be sued for it, the less likely people are to obey copyright. Is the argument. The more you know that, well, okay, maybe I'm breaking the law, but who really cares? Nobody's going to sue me. The less and less relevant copyright becomes to the ordinary people. Yes.
But I guess isn't part of that argument that fair use for relevant in the sense that when taking into account the commercial impact on the original author or work copyright holder. So in a situation that it might be intended for a private purpose, but the ultimate effect is a commercial impact on the copyright holder. And obviously in a modern time like this, that there is that effect. So although the private purpose might not the private purpose doesn't really matter, it's sort of more the commercial impact of it. I think it's fair use better covers that in the sense that you might have a situation where there's no intent, but because there's a specific exception, you can't really cover it.
I think that you can definitely say that a lot of people say, and I definitely agree. I agree that fair use is better able to cover this stuff because it does allow for these things that don't have the intent. But because it has this, impact on the copyright owners, it has the ability to still allow copyright owners to sue for ones that do impact them commercially. So the grey area stuff like piracy, downloading music and stuff, not even sure how much of the grey area that is, but there's a very strong case that would not satisfy fair use. In fact, there's been court cases in the US that says it doesn't. And so therefore you can open up, make it more flexible, without necessarily making it open to complete, gung-ho, laissez-faire, anybody goes, copyright infringement. This is the argument that the, fair use is better than fair dealing side of the argument uses. I've been talking for a fair while, but I can cover more of the arguments if you like.
We'll come back to this. So yeah. I think we might hand over to Trish.
Is that the microphone?
Just this microphone.
Alright, I might turn this around a second. Okay, so Excellent. I want to talk very quickly just about some of the uses that we see going through as fair use in the US that we don't have in Australia, just to give you some really hard practical examples of where the deficits are in the moment. Before I do that, because I'm a compulsive lawyer, just to squiggle back to the conversation we had, when we're talking about private and domestic use, one of the biggest things, as Jess said, is you've got to remember the move to the internet. And so while there are barriers to entry about suing people, there are decreasing barriers to using content ID to match content online and then do things such as, well, speculative invoicing, where you send somebody a note that says, I've noticed you've used my photo, or I've noticed you've knocked up a picture of the Disney princesses, you've put it on your child's wall, you've then posted that photo to Pinterest, you've infringed my copyright, take it down, and while you're at it, please send me $200. So we haven't seen an enormous amount of the actual final step of letters, but speculative invoicing is definitely increasing in the areas of, say, piracy in other jurisdictions. The potential is there for this to increase.
And to add a bit of colour to the speculative invoicing, so let's actually normally say, you know, you've infringed my copyright, you are evil for this, and give me $2,000 or else I'll sue you. Rather than saying give me $200 in a relatively reasonable manner, they often do use very scary things to try to get a lot of money out of it.
So moving from private and domestic use, I look after copyright interests for what you could broadly term the institutional user group. So universities, schools, libraries, cultural institutions, and the tech sector are my main member organisations. And it's in these areas that you actually see a vast difference between what you can get covered with fair use in the US and what you can't do here. Now, the example that everyone will trot out, and I will trot out because it's so fundamental, is you cannot run a search engine in Australia. Just straight out, we could not do it. And you can get that from any of the people who cheerfully run search engines in the US. Now, there are two parts to this. One is the fact that we don't have safe harbor provisions, which I'm sure Dylan will talk about at some point in another lecture. But the other is just that fundamental decision about fair use. So in order for a search engine to work, or for something that indexes, and in fact basically most of the web to work, what you need to do is a constant amount of copying. For a search engine to go through and be able to index things, it needs to make copies. And each one of those copies can cheerfully infringe that direct copyright of copying of a material. In the US, you can cover that sort of transformative use under fair use. The court will look at it and go, well, what sort of material are we using and how much? Well, we're using a lot, but what's the direct impact on the copyright holder, and is this a transformative, socially beneficial use? And the courts can say yes. Over here, the legal risk is too high for you to even try. So search engines are one thing. Platforms. So you trying to host something like YouTube or even Blogger or Pinterest here, where you've got no safe harbors and no fair use, absolutely stupid idea. And it's one reason that the homegrown tech sector and the startup culture has so much trouble. So if you don't mind the fact that you host everything overseas and you've got lag as it comes over, that's one thing. But if you think you should be able to host some of this stuff in country, fair use is probably a really good first step. Moving through to education. Education is a special case because as well as not having a fair dealing for education, they also have what the statutory license. We talked about statutory licenses.
A little bit, yes.
Okay, so you all know about statutory licenses, just nod. No, okay. So there are two giant licenses that go over the entire of the education section. They are called, in scintillating lawyer terms, Part 5A and Part 5B. One covers broadcast material, and it basically lets universities and schools do whatever they want with broadcast material and pay for it. Then the other one covers works, and it allows schools and universities to use up to 10% of a commercially available work or the entirety of a non-commercially available work and pay for it. The collecting organisations survey the schools and the universities and work out how to distribute it. The net result of the interplay between no fair dealing for education and the statutory licence is that schools pay to use Google Maps. Schools used to pay fact sheets that are cheerfully available for anybody else to download online, because they go and there's a closed copyright thing at the end, just because it's free to print off for everybody else. For a school, that will be collected and counted under the statutory license, because there is no fair dealing exception. And when we're talking about this, it's always important to remember just how narrow our definitions of fair dealing are. So we all know there's fair dealing for study and research. So a student would be quite able to go into a library and photocopy a chapter of a book. And that would be covered under fair dealing for research and study, because they've actually got set amounts in that one. But if a teacher does it on behalf of the student, the teacher is not doing it for their personal research and study, therefore it does not fall under the fair dealing, therefore it is paid for under the statutory license. And we've got very clear jurisdiction on all of this. And then finally, when you look at things like libraries and the cultural institutions, they don't work under fair dealing, despite the fact that this is what we generally talk about, fair use versus fair dealing. There's another section in the copyright, section 200AB, another one of those scintillating titled provisions. It looks after education, but only if it's not covered by the statutory licenses, so it doesn't cover much. Disabilities and cultural institutions, mainly libraries and archives. It is a similar formulation in some ways to fair dealing, but what it actually does is basically pull straight in the Byrne three-step test. So when you're using section 300AB, you've basically got a five-step test. You look at whether it's for one of those three purposes that section 200AB is done. You check to see whether any other exception or limitation applies, and if so, you cannot use it. Then you run through the Byrne three-step test, and then at the end you make sure that you're not making profit. And if you manage to do all of that, you fit under section 200AB. The things that we don't know if we can fit under 200AB are things like digitizing newspapers to put online. They are things like digitizing settler or World War I diaries. Now, here's some extra important things to remember. Everyone knows what the term of protection for unpublished works is, right? Anyone know what the term for protection for unpublished works is? So unpublished works are in perpetual copyright. Eternity. Forever. So general copyright term for anything that was in copyright on the 1st of January 1955, copyright term is generally death of the author plus 70. But for unpublished works, copyright term never starts to run. So there are some really specific library exceptions that will allow you to publish unpublished works 50 years after the death of the author, at which point you will have a copyright term of 50 years after that. But until something is published, that thing is in perpetual copyright. So if you've got a settler's diary from 1810, it is still in copyright. So for libraries, and the National Library has, for example, 2 million unpublished works, about 1 million of which are orphans. Trying to make those discoverable in some online platform is basically just a flagrant breach of copyright. And so that's another area that the cultural institutions would really be looking to for fair use to pick it up.
All right, I think we'll hand over to Nick to make some comments.
No, we won't.
Okay. Can you hear me?
Not quite. Just a second.
Should be able. Do you want to try again?
I'm talking now to you through the internet.
All right, have another go, Nick.
I am also still talking. Can you hear me?
Where's the
Well, we
speaker
can
on
hear you
the
with this
thing?
forward. It would be this microphone. Hang on.
Where's
Let's try it again.
the
All right, try now, Nick.
Okay, how's that? Any good?
It's a bit better. You hear him? All right.
Can you guys hear him okay? Go ahead.
All right, go ahead, Nick.
All right. So thanks, everyone. It's great to be here virtually. Look, I don't have too much to add on from what Jess and Trish have pretty well laid out the arguments, the main structure of the arguments for fair use. Look, fundamentally, what interests me the most about all of this is why this is such a difficult question. No one seriously thinks that fair use is a bad idea. The argument revolves around an argument that fair use for Australians is a bad idea, because the main opponents to fair use are the large American copyright industries, the MPAA and the RIAA, who represent the creators, the publishers of music and films in the US. The argument basically runs that fair use is a critical component of I'm sorry, I'm getting told that there's a lot of feedback on my microphone. I'm just...
No, you're okay.
So fair use is really important for all of those industries to do what it is that they do. It's an important part of the copyright balance that helps creators actually create things. It's just that the Australian industry hasn't really been that effective in making those same arguments. Now, so it's really interesting, actually, because for all intents and purposes, fair use is a no-brainer. It provides some balance to copyright law, it helps creators create, and it avoids some of the really annoying bits that make consumers lose respect for copyright law. So if you care about the idea that copyright law should make sense to consumers, then having an exception that allows people to do format shifting, private use, so on and so on, to just get out and do the things that we do with copyright material, it makes a lot of sense. And the problem with not introducing fair use is that people start not to believe in the rest of copyright law. So you only have to go to YouTube to look at all of the videos that are uploaded there, and you see this happen all the time. Under the comments in a video, there's there'll often be a statement that says no copyright intended, and this is people making up their own rules for what should and shouldn't be copyright infringement. So fair use fixes a tiny proportion of this. There's so much of copyright's problems that fair use doesn't even come close to fixing. The fact that it lasts for far too long being the most visible one. But fair use at least provides an outlet for, or a safety valve for, some of the more routine infringements of copyright that we don't think should actually constitute infringement. So then you get to the argument that was already raised. If it's not broken, why fix it? And I think Jess and Trish have given us a really good answer to that. The first answer is that just tolerating these uses is bad for our system. That we should have a copyright law that makes sense to people, and it should be respected by the people if we're going to have it. So it makes sense to exclude those bits from infringement. The second bit, sorry, I am having just a little bit of technical trouble here. The second one is the one that Trish raises, that there is that it really does matter for institutional users who can't rely on the chance that they won't be sued in order to get on with what they need to do. So for me, what's really interesting here is the fact that this is even a debate, and what that tells us about the international structures and politics at play in copyright reform.
I might have a few quick words on fair use then. So I think what the talks have demonstrated is that there is a genuine need for us to have fair use, and I see the Kookaburra case as illustrating why Australia does need fair use. That was a decision that went against the secondary creators, but the use that they made of the original work was quite transformative. So in terms of creativity, in terms of having the flexibility to allow culture to develop and to move forward, I think that there is a very sensible case for Australia to have fair use. I also think that there are significant statutory interpretation issues around the fair dealing concept. Its narrowness is a problem, and the fact that some of the key cases of pre-digital era is a significant problem, but the statutory interpretation issues are problematic, to say the least. I also think that the paucity of jurisprudence within fair dealing is a problem, and that's something that doesn't get much commentary. But the fact is that if you're a small creator and you're thinking about doing something that might be a fair dealing but might not be a fair dealing, you're going to look at the cases, and the cases will tell you what you can do and can't do. The problem that creates is that if some of the things are covered in the cases, well, you might have an idea about what you can do. But because there's not critical mass of jurisprudence, you may not know what you can and cannot do. And you, under those circumstances, be reluctant to do a dealing and to do something with the copyright. In stark contrast, there is, given the sheer size of the United States, critical mass of fair use cases. So if you're looking for an answer, the possibility is that that answer exists or will shortly exist, because you can't be alone in having these concerns about particular uses. So fair use has that significant advantage. The disadvantage, I think, is the three-step test, and my view on that is that whilst it might be okay, under the other two steps of the three-step test, it falls down in certain special cases. And so I've got a response to how you deal with that issue, but I'll just say briefly that I think that there's a problem here in terms of people commenting on fair use in the three-step test, is they conflate with what they would want to have with what actually is the position at law. And those two things don't fit together. And when you're giving your legal opinion on a matter as a question of doctrine, I can see Nick already shaking his head, but if you are giving your legal opinion on these things, you have to take a step back and just put to aside your preferred policy outcome and simply deal with the black letter issue. But I think the black letter issue runs against us on the fair use question in terms of certain special cases. Having said that, there is enough certainty within the sub-doctrinal strands of fair use as to the transformative use cases, the market failure cases. There's enough certainty to say that, well, if a transformative use is a fair use or whatnot, or a transformative use is not infringement, then that should be enough to get past the three-step test, because the concept is defined with sufficient particularity. The cases are consistent. And so if you read through the academic commentary on fair use, there's this whole branch of scholarship that says that fair use is incredibly inconsistent. It makes no sense. But then there's this more recent brand of scholarship, and you've got Matthew Sagg, Samuel Samuelson, Barton Beebe, and they're saying, well, actually, if you look within the categories, it makes sense within the categories. There's certainty within the categories. You can't get around the words certain special cases, and if you run it on the doctrinal categories, you might have a chance there. But if you run it simply as fair use itself as an open-ended exception, I can see problems. Nick, I think you've got some words to say.
Thanks, Dylan. I would urge you to have a look. I'd urge the audience to have a look at, particularly at the Max Planck Declaration on the interpretation of the three-step test. And I'll just make 2 points, I guess. One, that there's a lot more flexibility in the three-step test than I think we sometimes give it credit for. We tend to be very risk-averse, and maybe it's something about how we interpret things as lawyers when we're reading through this material, that we could take a restrictive interpretation, but I'm not exactly sure that that is necessarily the correct interpretation. The second point, in your advice, if you're advising a government on this, then you have to think about the practicalities too. Who exactly is going to sue a country like Australia for breaching international obligations under the three-step test? Because by implication, we know that that if the US is not going to answer to the WTO for breaching the three-step test for introducing fair use into its law, I find it very hard to envisage a situation where Australia could be in breach for introducing the same provisions.
South Korea, Israel, and the Philippines.
And Singapore.
And Singapore, there you go. I thought of Singapore as well. Anyway, and so far nobody has been questioned. Basically, if you question any individual country, you have to question the US, which is like a giant behemoth, and nobody wants to do that.
Let's say even if you have a look at, say, Samuel Ricketson, who's one of the more conservative writers in this area, even he will, in some of his works, has looked at the three-step test and the actual available jurisdiction on it, which is basically not much at all, and said, yes, no, there probably is some flexibility to at least get a lot further than we've got with fair dealing. Could I rewind for 1 second back to the artistic point?
Yeah, absolutely.
No, I'm just going to do a complete another plug for something that I put up on the internet. So the Australian Digital Alliance has a web page on YouTube, hosted in America, of course, and we ran a conference earlier this year. The final session had 3 creators, so 3 Australian domestic creators talking about copyright in their work. And it was fantastic because what it was 3 actual creators, not 3 publishing representatives, not 3 movie representatives. And their experience of copyright is quite different. So Melinda Smith, who won the PM's Literature Award for Poetry last year, for example, one of the things she likes to do with poems is take a poem and take each line and then write a new stanza underneath, which is a time-honoured traditional poetry format. When she wanted to get a license to use the poem, the license to use that poem was going to cost her $20 more than she would get paid for publishing that poem. When we're talking $20, to give you an idea of the scale we're talking $70 to $50. So for a lot of Australian creators, a lot of this is very academic, except that when it comes down to actually trying to use stuff, they end up hitting a lot of barriers. One of the others was a guy called Scott Bridges, who teaches over at UC actually, and ran a satirical Twitter account called Rod2000, which some of you may have come across. A couple of people winced, they must have come across it. They then took that satirical Twitter account and turned it into a book. And one of the most fascinating case studies he had was they'd just stolen a picture of Kevin Rudd off the internet somewhere, because it was a satirical Twitter account. But when it came time to publish it, their editor said, you can't just take some random photo off the internet and publish it in a book. That could get a suit. So they got First Dog on the Moon. You know First Dog on the Moon? Yep. So they got First Dog on the Moon to draw them a picture of the photo, and then they used that. And I'm sitting there, as Scott's explaining this to me, going, so that's an adaptive work and also a complete breach of copyright, right? But it gives you sort of an idea of the actual real practical challenges that face creators. I was just...
Can I just briefly, I'll just briefly respond to Nick on the 3-step test. You can fire back at me, Nick, as you please. I'm glad I'm in Canberra and you're in Queensland, so it's all good. Just on the Max Planck Declaration, I think that it's great that there's this scholarly community pushing for a reinterpretation of the 3-step test. And one of the important points about international law, of course, is if you put something in the treaty, the pactum can shift. If there's critical mass of thinking amongst the contracting states, the meaning of the provisions can change. So we're not completely locked into the wording and the restrictiveness of the wording seems to suggest. However, we're not there yet. We haven't shifted the pactum. This is where I think we've got a significant disconnect between what the Australian government says when it's talking to user groups and what it says when it's talking to owner groups. And if you look at what it does in international relations and what it's doing with the TPP and all the rest, to some extent Australia is rather Janus-based on copyright. It's all open access and all open this and that when it's talking to the user groups, but then it seems to shift. And if you look at what they actually do as opposed to what they say, they're ratcheting up intellectual property rights. And the 3-step test is proliferating in all of the FTAs without any statements as to the pactum shifting on what certain special cases means, or much less any of the other steps, and they're all cumulative. So we might get there at some point. I certainly agree with Tricia's point. The Ricketson is right. There is scope to push us further than where we've got at the moment, but whether there's scope at the moment to have fair use, I'm not so sure. I also don't completely accept your point on the United States. Sorry, not being different in terms of how if Australia gets the 3 fair use, that no one will challenge us because challenging us will be challenged in the United States. I think the plain packaging laws show you quite simply other countries will take a shot at us. We're not big enough to simply just palm them off. Okay, I'll let you respond to that and take it further.
No, I don't have anything more to say on that, but I'm happy to take questions.
Can I talk about practicalities on that?
Sure. Just want to
No, it's okay. You could. I'm going off.
Just from a really practical point of view, I think there is something to remember that when the three-step test came into effect first, it's a Berne Convention, it's a WIPO convention. You're looking at, let's face it, one of those nice, good feel international bodies where people talk and we reach things by consensus. The minute we hit it through TRIPS and it came through the WTO, it became so much more enforceable, it's not funny. And now we're putting it into trade agreements, and in particular, we are putting it into trade agreements which will have ISDS in them, so investor-state dispute settlement. Now, there's a carve-out for the TPP. Of course, we don't actually know anything, but if you look at the leaked investor chapter, there's a carve-out for IP, but there's a carve-out as long as a country applies IP laws in accordance with the IP chapter, which actually gives you potential leverage to see a company or a group of companies suing a state. And at that point, there is a possibility that you might see something in the nature of litigation around exceptions. I kind of hope it won't happen, but if we're going to talk about practicalities, that's something to keep in mind.
Thanks, Jess.
All I was thinking is, I was thinking that we haven't really covered all of the arguments, and you should, in fair, because obviously the conversation from several of us are very, pro having fair use. So I thought that we should at least say out loud some of the other ones so that you guys can look them up later if you want. One of the other ones that used to get raised a lot actually in my day before the internet really took hold was that people didn't want to lose our own law. They basically, fair use, is a creature of the US primarily, and they were saying we're going to wholesale import all of the US law and lose our own local precedents, and it'll be, everything's going to be thrown up in the air and there'll be uncertainty, and that's terrible for people. I do think that it's possible to legislate around that, and I think honestly even the way the US's legislation is written, if we imported it into something similar into Australia, we'd import all our own law, because it does mention exactly the same purposes. It just doesn't make them an exclusive list, they're an inclusive list. So I think that it is possible to get around that, but that is one of the big arguments that people use. And of course there is there's a big argument that, because it actually relates to what Dylan was saying, that Australia is always going to be too uncertain, too small a fish to have something like fair use, because we aren't going to have enough litigation, and therefore the uncertainty surrounding fair use is going to go on forever and ever. I personally am somebody who thinks that is not a strong enough argument to, I feel I'm more disturbed by the fact that huge amounts of behaviour, both by consumers and by businesses, it's very important to remember that this impacts, tech companies in particular, but almost anybody who's trying to invent or change things in the IP field. I don't think that the fact that we're just saying they'll be right and we'll just trust that copyright owners are not going to sue them, rather than giving the courts the decision as to whether or not what they're doing is illegal. You're essentially kind of saying we're just going to make it illegal and trust that the discretion, that copyright owners are going to be discreet in how they judge, as opposed to giving the discretion to judges. I don't think that that's a strong enough argument, but other people do feel very strongly about that. And I think a lot of the divide here, as you can even see on our panel, is between people who are, black letter lawyers, people who are providing advice, can we do this without any risk? No, it's impossible for a lawyer to say that. And the people who work in practice on the ground, which is Molly and Trish. Actually, Nick, you're the other one, but you're still on our side, which is interesting. Who are saying, in practice, we really should just go ahead and do this to make the system work better.
Okay, let's open it up to some questions. I think that there are a few in the rooms in the corner there.
Sorry, it seems correct to cover on this. I've got a lot of these issues from the duration of the license. You touched on the fact that unpublished work, surely you touched on the fact that Clark has been responsible for the use. Is there an argument that if it was reduced, if the term was reduced and it came back to what it was, that issue would never risk in the Clark case copyright, and then we also wouldn't have to worry as much about unpublished work. Is that an area can we get much better for reform and what else to do in that area?
So for the recorded people, the question is, does this issue stem a lot from the extension from how long the copyright term? how long it is, and the fact that it's extended, etc., etc. And the reason why I wanted to jump in and answer is I actually think you've got the question. I'm going to flip it around the other way, and in fact, what it is that introducing fair use would reduce some of the negative impact of the extension copyright term. So this issue definitely predates the extension of copyright terms. It's completely separate from it in many ways, and that it's always existed. It's just how serious an issue is it, and it's been made much more serious and much more public by internet and new technologies. But it has also been made much more serious by the extension of the copyright term. And if you have fair use, then for people like libraries and individual users, fair use counteracts a lot of the negative impact of the extension.
From a practical point of view, just flagging, if any of you end up with copyright term on an exam paper or anything, things about the copyright term extension are, one, on an economic front, it's bad for Australia, and there's some really good stuff from the Productivity Commission. I think it was $70 million per annum back in 2006, the 20-year extension on most works was when we signed the Australian-US Free Trade Agreement. The other thing is that, of course, it's very different from the term in all other intellectual property. So copyright is substantially longer than terms in other intellectual property. And most important, copyright is different because it has no form of registration system. It has no form of sort of use it or lose it capacity within there. And obviously, we can't do most of that either, because one of the international things that we continually agree to is to have no registration on copyright. No formalities, if you want the technical right on your exam term.
Okay, I've got a question up there.
Yeah, I just want to ask a question, just listening from the we had last hour. So we kind of have learned that part of the rationale of copyright is to try to get to both science and art. And there's some argument that not allowing fair use and not allowing transformative because you want to protect the rights of these copyright holders who are often big companies, not the authors themselves. That's actually like preventing creation. And so do you think that by not having fair use, we're actually kind of allowing, like, it's just sort of counterintuitive in terms of the objectives of intellectual property law and would you agree with that?
Yes.
So the question is about the rationales for copyright law and whether not having fair use is actually stopping creativity and the like. And I completely agree. I think that we've now got ourselves in a position, and bloodlines and larrikin music just illustrate this. It's almost ridiculous. That the comment, I mean, how are people going to create? There are only so many things that sound good. And so at some point you basically give ownership to the people who are first in time, and you leave nothing for the second, third, and fourth authors. And that, given that there's a human need to create and to continue to create, basically copyright law then stops serving the community as a whole and just serves narrow economic interests. And that's unacceptable.
Which brings us back, I think, again to that first question, which shows how interrelated all these issues are. Of course, it has to do with the length of copyright that's just far too long. None of these things would be a problem if copyright was confined to a much shorter period of the useful duration or the useful commercial life of products. But the fact is that fair use is pretty much the only flexibility that we can introduce under the international agreements. If you accept that, then if you don't, if you accept Dylan's argument, then there's not much we can do, which I'm much more depressed about.
All right, we've got some questions in the corner over there.
I heard some of the academic concepts on transformative to doctrine, not as a set of exceptions or I think exceptions, but it's connected to what copyright was originally and the scope of copyright. Can you argue that the fair use cases are actually special cases that were never covered by copyright and aren't in the scope of the exception?
There's an argument there. I certainly think that we made this point about fair dealing last week, that fair dealing basically stipulates where you don't have copyright, where the borders are, as to uses which are actually in the public domain. There is an argument. How that argument would be received before a WTO panel, I can't say with any certainty.
Because I think the flaw is that what you would actually have to argue is they are things that shouldn't ever have been copyright. covered by copyright and were never intended to be. And that's the problem. You can't just say they never were, because going from that initial, the Berne Convention, we've had so much stuff put on top of it that basically draw them in very clearly.
And again, anytime you're doing something on the three-step test, it's really important to know which iteration of the three-step test you're talking about. So when you started off with Berne, you actually had a whole heap, in the first bit, a whole heap of exceptions, and then you had the three-step test to any additional exceptions. By the time we've hit the WTO, and definitely now in free trade agreements, we've just got all exceptions subject to the three-step test.
Okay, I've got a further question in the corner there. So, yeah.
Is that when it's too entrenched? We're too far down that, we've got a naturalist, we've got a narrative, we've got a we can't revisit that and alter it now that I've got.
Okay. So the question is the three-step test too entrenched because of its position with international? I think the man to answer that is Nick. Do you want to say a few words?
Is it too entrenched? Well, it's an interesting question. Yes, it's definitely entrenched. Yes, it's a problem. What do we do about that? Well, we can resist. We can promulgate more expansive interpretations of the three-step test, like for example, the Max Planck Declaration tries to do, to reclaim some of the public interest that has been ceded to corporations over the last 30 years. We could try through international fora to change international copyright laws at all of these different levels, which means for a start not signing up to continual expansions of the or continual extensions of these tests through bilateral and multilateral agreements like the TPP and the various trade agreements that Australia is party to, and then try to drive some sort of positive change through international organisations like WIPO. I'm somewhat optimistic of the potential of WIPO to come to better readings that protect the public interest in a way that they haven't been able to before, and the Marrakesh Treaty is an example of that. But I'm also pessimistic that if WIPO continues to follow down that road, then it will increasingly be marginalised, just as we're seeing it marginalised through the bilateral and plurilateral trade agreements. So yes, it's a problem. It's entrenched and it's really tough to get out of it. The other way out is to keep doing what we're doing, and for people to get on with producing things, using things, and making money from producing and using things. And slowly some of these tensions will go away. Now, that smacks a little bit of technological determinism, but attitudes are changing towards how things are playing out now that the internet has really changed the ability of people to access wide audiences and the ability of people to create much more cheaply than they ever have before. So there's a practice-led component of this too, that as practices and industries change, then slowly international understandings might also change. But yeah, we're in a fairly difficult place.
Okay, we got any other questions? Yeah, that's back.
Just like more like a general question. If we were to move towards, say, like a fair use approach in Australia, to what extent do you think transformative has to be incorporated in? Like obviously, like from what I understand, like the American approach, you've got these legislative factors which are considerations, and of course, like, oh no, but it's transformative. Oh, but it is substantially for the nature of the work and blah blah blah. Like, we can't in Australia go, oh, let's adopt the American policy of this bit of legislation and these factors, but also the court's going to do this. So, like, I want to put your thoughts on how transformative use should accompany fair use in Australia because of such a policy.
Okay, so the question is how transformative use should accompany fair use if fair use is brought into Australian copyright law, and I guess how it will be treated. That's a difficult question. My personal position, as I've said, is I think that break down fair use into the rules that work. And if you look at the transformative use cases, if something is transformative, it tends to then win the fair use argument. And so there is a sort of default position that a transformative use is actually a positive thing, therefore we'll put it through. Put it through as a free use exception then. A transformative use is a free use exception. And As long as we define what a transformative use is, and I think Pierre Laval in his paper on fair use in Harvard Law Review, which in turn inspired Campbell via Carp-Rose, offered some very useful definitions, and I've given you that paper, and I think it's worth reading through those ideas on transformativeness. I think that gets us around the difficulties of the three-step test. I think it also gets us around the difficulties of Australian judges in Australian courts importing US jurisprudence in Australian litigation, which might have some interesting results, but it won't give us the certainty which I think we want. And transformative use will just open up space to do things which are more exciting for creators. Other thoughts, Nick?
Yeah, couldn't agree more. I think that probably the easiest way to accomplish a lot of this is there's also a really interesting argument made by Derek Bambao along the same lines. Let's just read down the derivative works rights in the US, or what we call the adaptation right in Australia, back towards its core, so that things that are not uses of works that are not within the core market of the copyright owner are not infringements of copyrights. And you can achieve that by just reading down reproduction. And I don't think that you have the same problems that we've been talking about with international law here.
Close we are to finishing, but I think Nick's point actually pulls in something I was thinking of talking about that didn't end up bringing up, which is how much this links through to a lot of the other changes, and I suppose it relates to the term thing as well, that have been made to Australian copyright law over time, and how much fair use really can be the reason. One of the reasons why we need fair use in Australia is because of the changes that we've made over the last decade or so that move us far towards, like, you know, the US system primarily, but you move us towards a tighter system that tighten up definitions of reproduction, tighten up definitions of substantiality, all those kind of things. We've made all these changes that reduce this kind of freedom that Nick's saying, where you could actually say, well, it's not even captured as a reproduction, or it's not even captured as a work. Australia has got tighter and tighter over the last few decades, most of the time, on these things, without introducing any counterbalancing ability for users to say, okay, well, even if it is a reproduction, I can still do it in these reasonable circumstances. So the point is that we're expanding the scope of what is protected by copyright and what activities are in potential infringements of copyright, without also leaving an escape valve. And that's the big difference between the US and the Australian system. The Australian system, prior to the free trade agreement and to some degree the digital agenda reforms, was actually, I think, an extremely well-balanced and nuanced system that came up with solutions that, you know, let copyright owners and users have a fair amount of freedom and rights in the system, and with a fairly good balance. Then along comes these other, the internet, and starts pushing us all to making uniform laws around the world. Those uniform laws are being driven by the copyright owners, and they're getting tighter and tighter. And and in the US, this is fine. The US is okay because they have fair use. It gives you an escape valve. We don't have an escape valve like that in Australia. So what we have instead is we have continuous introduction of these very small specific exceptions that are supposed to deal with new uses that everybody agrees should be allowed, that are extremely specific, are always introduced after the fact, and almost never cover even the use that you're addressing completely, let alone the uses that have arisen by the time you get through the legislative process. So the perfect example of this is the iPod exceptions, like the private use, space shifting of your music exception. You can get your CDs, you can copy them onto your computer now. That's excellent, except by the time that they actually got round to writing that, not only had it been around for, I don't know, at least 5 or 6 years, that use, but video, iPod stuff already existed, but they were terrified and too afraid to put video in there too, so it still only applies to music. So it's still illegal to do exactly the same thing with DVDs. Probably even better one, actually, I just thought, is time shifting. So recording TV to watch later. We finally got an exception on that 22 years after the invention of the video player. And for 22 years, everybody in Australia who ever taped a TV show to watch later was infringing copyright. And we just relied on the fact that nobody was going to be sued. And it just gets a bit ridiculous. And then when we do introduce an exception, we have some bad habits, not all the time, but occasionally you introduce an exception that's for videotapes, not for audio-visual works, but they actually use the word videotape in one of the specifics. Yeah, exactly, which means that anything that came after that, or anything that came before it, like 8mm films, you know, all these films that pre-existed videotapes weren't covered, everything digital that post-dated it isn't covered, only videotapes. So that's why you need something a bit more like fair use, to allow for the law to adapt to things before we can do it with specific exceptions. Australia has always done specific exceptions. I actually like specific exceptions. I get their appeal to people. It makes much more certainty. It allows you to think carefully about what circumstances people can and can't do it. But it's just things change too quickly nowadays. Things didn't change very quickly for the first few centuries of copyright, and now they do, and we need more flexibility.
You want to say anything?
If we're going to talk about the marriages of these sort of things, so when the ALRC recently put down their recommendations for fair use, they had key recommendation fair use because it's the one that's actually going to be adaptable and sort of future-proof the whole thing. If that's politically unpalatable, then extended fair dealing. And the thing about extended fair dealing is trying to find a reason that still has enough flexibility in it that you can carry it through to new technologies and new uses as it comes up. And at the moment, to be honest, I'm not 100% sold on what we ended up with as their reasons in fair dealing, all of them. But in the discussion paper stage, they actually had one for non-consumptive use. And it was very much the idea that you could, if you were using a copyright work in one of the ways reserved for the copyright holder, so reproduction or communication to the public or something, but you weren't actually using it in a consumptive fashion. So it's a film, but the process that you were doing was just a technical one to transport it. That end one where somebody actually consumed it, that's one thing. But something in a technical process, that's a non-consumptive use. So, and same would go for a lot of indexing, a lot of ordering and making of contents and databases and conversion, all of that sort of stuff would be non-consumptive. And it's some of those key terms, I think, that are the edges of where we're looking at, well, what does copyright cover? And thanks to the Australian-US Free Trade Agreement, the reproduction rights extended to the digital and everything is covered. What does copyright cover? Does it still tie in with what it was originally meant to protect? And is there some way in our exceptions that we can carve back to keeping it just protecting what it's actually meant to protect, rather than catching up all the incidental things that just make the world work?
Okay, well, I think in the interest of time, we should probably make some closing remarks, and I'll say one or two things before inviting Nick to say a few words, and then if others have some things to say, we might end there. So I think we've gone through at least 15 years of either government reports or other committees basically making the recommendation that we should have fair use, and at some point something has to give. We can't keep going through this process. So we need to begin rethinking how the 3-step test operates and what its wording should be, and we need to seriously think about how we would bring fair use, either in different pieces or as a whole, into Australian copyright law and what the benefits would be to our society. Okay, Nick, would you like to say a few things?
I won't say too much more, except that I guess for me what's really interesting, we're going to have to do more than that. If we're thinking about designing a copyright law that makes sense for the digital environment, for the world in which we live in, if we think about a copyright regime that achieves the objectives that it sets out to achieve, I think it looks radically different to the one we're having, the one we currently have. Fair use is such a small component of this bigger problem, and the international discourse is going to eventually have to move beyond the restrictions of the Berne Convention and its progeny. It's going to be a long road, but there's going to be a lot of change that's required to get there.
Yeah, I kind of like to echo a bit what Nick said, which is it's probably important every now and then to get copyright back down to absolute brass tacks. And one of the things, for example, in a completely different realm of copyright, the online copyright infringement notice scheme that annoyed me recently, was when you were looking at what their evaluations were, there was nothing in there about, say, making sure that we supported Australian creation or supported Australian creators' incomes even, or creating an ecosystem that would thrive. There was very much a sort of drive about, well, if we stop piracy, all is good. So I think when you're talking about the big copyright debates, it's important to think about why would we even have copyright? And if you get back to that sort of fundamental things about promoting and supporting creation and distribution, and it's important to remember the distribution bit, then yes, as Nick says, if you reinvent copyright, you would just not end up with what we have now. But we've got what we have now, so I guess from the practical point of view, it's what can you possibly do to make it work as well as possible?
And I suppose my closing remark is just going to be that I think from a practical point of view, it really, having fair use in the modern era really is a bit of a no-brainer. From a realistic point of view as to whether it's going to be introduced, I don't think yet. I don't think under the current, powers that be that we have, but I do think that we are moving closer and closer. Every single time we have one of these studies that Dylan talks about, it gets more and more. They get more and more stronger in favour. There's more and more. It seems more and more likely that maybe it will happen, and so I think that sometime in the next decade or so, I think we're going to tip the line over. But in the next year or so, I'm very sadly disappointed in saying I don't think it's going to happen. But I think we should do it. We should be brave.
Well, there's a lot of food for thought there. I think we're obviously sort of sleepwalking through the 21st century with some 17th century ideas, and that's not a happy way to be. Can you please join me in thanking Trish, Jessica, and Nicholas for their Right, and that's us for today. I look forward to seeing you after the break with your assignments.
You see the weird think tank of the EU that put out a study that showed that.
Thanks so much, everyone.
Hey, thanks, Vic. Thanks for that.